A Fairfax County Circuit Court judge has ruled that frozen human embryos can legally be considered property in a ruling that has been met with criticism from some. Judge Richard Gardiner's ruling was issued in a long-running dispute between a divorced husband and wife. Gardiner based his decision in part on a 19th-century law governing the treatment of slaves. Susan Crocken, a lawyer and scholar at Georgetown University's Kennedy Institute of Ethics and an expert in reproductive technology law, called the ruling repulsive and morally repugnant. Solomon Ashby, president of the Old Dominion Bar Association, a professional organization made up primarily of African American lawyers, called the ruling troubling. The ruling was in relation to a custody dispute between Honeyline and Jason Heidman over 2 frozen embryos that remain in storage. Honeyline Heidman, 45, wants to use the embryos, while Jason Heidman objects. Initially, Gardiner sided with Jason Heidman, but he reconsidered after arguments from Honeyline's lawyer. Gardiner concluded that embryos could be valued and sold, and thus could be considered goods or chattels. He also said that Jason Heidman's objections could violate his constitutional right to procreational autonomy. Honeyline's lawyer argued that her right to the embryos outweighs her ex-husband's objections. Gardiner has not yet ruled on the argument over Jason Heidman's procreational autonomy. The decision is not final and he has not yet ruled on other arguments in the case.